We begin in Ukraine.
Russia has invaded Ukraine.
A devastating day in Ukraine.
The war in Ukraine has brought the English legal system into focus. Witnesses have described to Parliament how freedom of expression is being stifled.
SLAPP it's an improper use of the law.
Where the ulterior motive is not to say, oh, you shouldn't have said that. The ulterior motive is to shut you up.
So why would claimants come to London?
Claimants have a history of jetting in crooks, brigands, arms dealers and celebrities jet in to launder their reputations in Court 13 in London. And the reason for that is that you have to be pretty much a moron in a hurry to lose a libel case in London.
It is a law that has been crafted to assist the upper class and to disfavour their critics.
Then there's the costs.
A defendant is looking at about £250,000 to £500,000 to defend a claim to trial.
It cost my publisher to fight all 5 claims. It cost them £1.5 million.
Of course, we have the same system here as we have in many Commonwealth jurisdictions where the loser pays.
Those costs themselves are the chill, are the weapon.
We don't have free speech here, we have very expensive speech.
This is a problem that goes back centuries and starts with the legal status of freedom of expression.
It was not recognised as a legal right until we got the Human Rights Act, Article 10 of which recognised freedom of speech as a human right.
English defamation law predates the invention of the printing press. Originally, it was a criminal offence designed to protect public order, and then later became a civil action.
It was originally designed as the remedy for the duel. Too many people were challenging their accusers to duels, and one or other of them would be killed. So it was rather better for society to have its leading members sue each other rather than kill each other. So to that extent, libel was an improvement.
That is always led to a presumption that the person who has been cited is an honourable person.
And then, of course, you get to the 19th century where social life was lived in gentlemen's clubs, and where there were people like Oscar Wilde were challenged, had nasty things written about them and penned up on the club notice board. So libel became a way of unblotting your escutcheon.
And that is the underpinning. So you've always got to prove that you are that the person who you cited has a poor reputation and that you've justifiably besmirched their reputation.
All but very few civil laws cast the burden of proof on the claimant, and only rightly, because it's the claimant who brings them to court. It's the claimant who wants money.
Whereas ordinarily, I think if you go to America and most of the civil law world, you'll find that the burden is the other way round, in that claimants have to prove that what is said about them is wrong. And that seems to me to be the appropriate starting point.
You're dealing with, you're publishing material that it's often very difficult to get to the truth, because the people you're reporting on have incredibly elaborate and complicated ways to hide the truth.
The Ministry of Justice's response is that it's too difficult to prove a negative.
It's not very easy. Negatives are easier to prove than positives. If you are accused of being a scoundrel or a false promoter of companies or whatever, you can go into the witness box and say, I'm not. This is false. That's evidence, and you can provide it. So it's not difficult to prove a negative.
We just have to look at the rest of the world. The global majority requires claimants to prove that they have what's been said about them is false.
So I think that is really typical of the Ministry of Justice. It's an unintelligent objection.
Then there's Justice Eddy, who in a 2009 speech questioned whether changing the burden of proof would make much of a difference, and he couldn't think of a case that turned on the burden of proof.
Well, it's surprising. I found many cases, including one or two before him, where it did turn on the burden of proof. And I think that is the reason why so many cases, seemingly good libel actions, are lost, because the judge is inevitably affected by the fact that the claimant has to, does not have to prove. It's the defendant who has to do the proving.
There was discussion when we came to the 2013 Defamation Act reform. Many of us lobbied for this fundamental change to be made then.
Yes.
And there was a political deal done behind the scenes, because some of those promoting the legislation didn't think that they would be able to get that particular reform through, and so they threw that on the bonfire rather than to press for it. Personally, I think it was an error of judgment, but it did mean that we got some modest reform guarantee.
Part of those 2013 reforms was the requirement that claimants had to show serious harm, though it's questionable whether this has actually made a difference.
Because all a claimant has to do to bring a libel action is identify an allegation which is relatively serious, and if it's in a mainstream or widely read publication, you will be over the line already in showing that that is serious harm to your reputation, which is the threshold.
Our libel judges are drawn from the libel bar. They believe in reputation and, of course, their entire careers, and those of their erstwhile colleagues at the bar are made on bringing libel claims, whether they're fatuous or unfortunate, in order to line their pockets. So there's been a great hostility amongst the judiciary in trying to deal with this issue of substantial harm, and they have gently eviscerated the test, so it's become meaningless in terms of using it as a defence or indeed a hurdle to surmount before you bring the case.
The passage of the Human Rights Act led to the development of privacy as a cause of action, with English courts now finding that reputation falls within the scope of privacy.
Well, the difficulty with privacy is that you don't want to stop investigations that are in the public interest. And I believe that the present law says, well, we have to find a balance. Let's balance the damage to privacy with the advantage to free speech. But these are not comparable values, and it's difficult. Judges talk of weighing them up, but you can't weigh free speech for the countryside against privacy for the individual. They're incommensurable. So what I think we should do is return to the position that Lord Justice Scarman had of having a presumption made in favour of free speech, which can be overruled if the invasion of privacy is grotesque. But the House of Lords, in its time, it was replaced by the Supreme Court, and the Supreme Court these days is far more protective of privacy than of free speech. But Article 8 sets up or demands respect for privacy. It doesn't give a right to privacy, it demands respect for privacy. And I think that is a different situation. All media cases should come under Article 10. Article 8 was made in the light of Gestapo raids at 8 o'clock it was introduced into the Human Rights Declaration in 1946 as a result of the appalling behavior of the Nazis in raiding places without search warrants. I mean, that's properly a question of privacy, and I don't think that the press should be belaboured by it, except in the Article 10 situation where it is something that overrides the right to freedom of speech.
So what's the solution to all of this?
The answer isn't a one single bullet, it's
Yes.
multifaceted. So yes, it needs judicial training. Judges who have grown up as barristers doing libel cases haven't experienced this in their practice, so they need to become more aware of the problem.
It would require reform of the burden of proof rule. It would require reform of the idea of balancing free speech against privacy. There'd be a number of reforms. It would bring it closer, and this is perhaps the most important, it would bring it closer to the American free speech position, where it is a lot more difficult to stop information coming out in America than it is in Britain.
The only way is for judges to stop cases which are essentially abusive of the system early.
Okay.
And that needs two things. It needs lawyers or judges to recognise when there is a SLAPP, when there is essentially a non-vindication motive to the proceedings, and to stop those proceedings in their tracks. Otherwise, what will happen is that we will increasingly turn up the financial pressure on people who are trying to out information which is in the public interest which we should all know.
Countries that were encouraged to take the American First Amendment path would be much happier than those that are throwing libel actions within society at each other.